Ageas, welcome to today's session. Fundamentally, it's an opportunity to reflect and ask questions relating to each of the four liability scenarios that HF produced in collaboration with our friends at 3P Barristers. And the real sort of opportunity today is for all of you to ask as many questions as you want. We've got some pre-posed questions kindly from all of you at Ageas, but to really use the opportunity to get an insight from members of council, some of who sit amongst the judiciary, from 3PB barristers. So with that, I will hand over to counsel Darren Walsh to introduce 3PB barristers.
Okay. Afternoon, everybody. As you know, I'm Darren Walsh, and you also know I'm a barrister at 3PB. I've been at the bar just over 23 years. My practice is predominantly fraud stroke low velocity impact kind of litigation. I also sit as a deputy district judge. We also have Tom with us, and we also have Hetty, although at the moment I can't see Hetty on my screen, but I presume she's there. So Tom, do you want to introduce yourself?
Yeah, thanks, Darren. I don't know if it's just me, Darren, but I can't see you. I'm not sure if your camera maybe is turned off. But anyway, whilst you're sorting that out, my name's Tom Webb. I'm 2010 call. A bit like Darren, a large proportion of my work is fraud and fundamental dishonesty work for the defendant. I also sit part-time as a judge, albeit I sit in the first tier tribunal dealing with benefits appeals effectively. Great, so I'll hand over to Hetty for her intro.
Sorry, just about to be joined on the dog starts barking. Hello everyone, my name is Henrietta Hughes, otherwise known as Hetty. I am 2012 call. I do personal injury and clinical negligence, and a lot of my PI work involves cases concerning fundamental dishonesty, effectively fraud cases. And I've been at 3PB a while now, based in London, but travel everywhere. I don't know if anyone else can see me. Probably doesn't matter too much, but okay, cool. Please excuse the background. I've just moved into a house, so everything is everywhere. But yeah, back over to Darren.
Okay. I don't know if we actually have some scenario questions first. First of all, in relation to Hetty's scenario, I think Hetty's covering scenarios 1 and 2, so I don't know if we have any questions for those.
Thanks, Darren. I was going to say, if anyone does have any specific questions about scenarios, as Darren said, go ahead. If not, you want to ask me anything more general now, Darren and Tom and I are happy to answer, and it may be we all chip in and help answer the question, or one of us answers. But as I say, unless there's any specific questions at this stage, I can address one of the questions that was put in advance.
Can I double check, because I know them by what was included, what the case was?
Yeah.
Rather than scenario 1 and 2, sorry.
Sorry. So the ones that I was dealing with was the collision on the roundabout, and then the motorbike one trying to overtake when turning into when the car's into a road. Yeah.
Okay. Thank you. Sorry, it's just
no,
just
you're
be
quite
me,
right.
but I'm sure if you say 1 and 2, some people
the numbering as well. So no, quite right. Well, if there isn't any specific questions, there was a question put in advance that have ranged from sort of non-fraud cases, but also fraud cases. What I will say is one of the questions was one word versus the other, and how that will play out in the LIP, I think presumably in relation to how that's in relation to litigants in person. Of course, everyone's word is on an equal footing. In terms of a trial scenario, of course, in terms of a claimant, the balance of probabilities is, of course, the test, and the burden is on the claimant. So they have that burden to surmount. But in terms of one word being preferred over another, that's not the case. Everyone is on an equal footing. Everyone, in terms of a witness statement, obviously signs a statement of truth. What I will say, though, is in terms of bolstering one word against another, and I have this frequently about, and forgive me if it's not quite answering the question, but I hope it is. What about family members or close friends or loved ones who, for instance, are in a car with said claimant or defendant? And sometimes they get to court, and it's no criticism of anyone, but witnesses or parties will say, well, I was told that they couldn't give evidence because it's my husband or it's my partner or whatever. That just simply isn't correct. Anyone who can give an eyewitness account of something that happened ought to be explored, and hopefully they'll provide evidence which is helpful. So although of course it's going to be an obvious argument by the other side, say, well, that's your husband or that's your best friend, having witness statements from those individuals really, really does help. So they don't just have to be a bystander on the road, an independent witness. They can be loved ones, and that does help strengthen one word against another, because of course you don't become one word, you become 2 or 3 words versus another. I'm just going to shut the window. This is the working from home, isn't it? All the
I think that's really interesting, Henriette, and I echo say that. I mean, we will always secure and serve if they're helpful witness statements from anyone, whether they be known or not known. A question at this point, and sorry if I'm jumping ahead, but Ruth, Ruth, you put a really good question in via Adam, which was how do we deal with witnesses who are under the age of 18, and how would you as a member of council look to sort of manage that from a sort of perspective of that court?
Well, I think, James, sorry to deflect to someone else, I think because we all sort of looked at different questions, I think Tom or Darren actually had sort of got something together in terms of an answer for this one. So I don't know whether if they want to step in at this point, and I can come back to anything.
I'm quite happy to do so. So first
Thanks,
of all,
Darren.
with a child evidence, you never discount the evidence of a witness, even if they're a child, simply because they're a child. Generally, bear this in mind, courts like children, because generally they think, well, children will tell the truth. There's always a smack of honesty about children. There are obvious pitfalls with children's evidence. First of all, of course, they may be simply too immature for the process itself. And the second bigger issue, of course, is that they've been overly influenced by their parents and their version of events of what's happened. That's something that you have to investigate carefully. But with children, I simply just ask yourself a few questions. First of all, what are the issues to be determined? Once you've decided that, well, do you need their evidence? It's rare that the only evidence you're ever going to have really is the evidence of the child. There is going to be other evidence corroborative of probably your account. So once you've considered that, then really look at, well, do you need the evidence to prove the case? If you do, then look at the child itself. So look at the age of the child, look at the maturity of the child, look at their willingness to give evidence. No child should ever be compelled to give evidence if they really don't want to do it. The length of time since the accident, I mean, inevitably with children, they've got more important things on their minds than a road traffic accident, for example. So look at the time between the accident and the child giving evidence. And then look at the reliability, what's likely to be the reliability and the quality of their evidence. As we all know with witnesses, it's not quantity, it's quality that counts. Although I completely echo what Hetty said in relation to non-independent witnesses. Just because they're non-independent doesn't mean they are not relevant witnesses, and you have to look carefully at their evidence. And in terms of taking their statement, we'll do it in the same way. The parents should be there, either a solicitor face-to-face, or more likely nowadays, it should be by telephone, but it really should be the child's account without too much influence from the parents. I don't know if anybody else has got anything to add to that, but that would be my take on children.
Thank you, Darren.
Can I ask a question on that from almost like an LIP scenario? Because obviously we're looking to take statements ourselves from our customers via telephone, send similar copies to them to make sure they're happy with the contents and sign and date accordingly. Would you say that we are within our remit to do a similar thing with children, obviously subject to them being old enough to really understand what we're doing, but do you think we're okay to do a similar process with children to take statements, or is that something that you would envisage an outside agent taking a more formal statement is a safer process to go down?
Yeah. I think with children, personally, the more experience, the better. So what I mean by that is I would rather it come from the solicitor side than an agent. Okay, no disrespect to agents, they're doing what they've been told. They don't have the experience and they don't really have foresight of exactly what the issues are going to come to be. They're going out to get a job done in a certain space of time for a certain fee. My view is, where children are concerned, leave the agent out of it.
Can I just ask something very quickly? Sorry. You were obviously referring to scenarios, but I don't think I've actually been sent them. I'm desperately trying to look through my emails. So I think Paul might be in the same situation as well. I'm just wondering whether they can be sent through. Sorry.
I can send it to you if you want.
Across now.
Thank you.
Just with the roundabout one, with this sort of assumption by most case handlers that roundabouts, and I know it's kind of briefly sort of addressed in the training, that roundabout collisions invariably always settle 50-50. And without sort of, so it's kind of in our mindset when we consider litigation further down the line, is it even worth running because it's going to settle 50-50? If you had to sort of, and it's probably a stab in the dark, but if you had to put a split on it, you know, if there were 100 cases that went to court, and I know they're all different in their own right, but out of 100, how many of those would likely settle 50-50 and how many would likely, because I think the difficulty we have as case handlers when it comes to roundabout collisions is, you know, the first thought is it's going to be a 50-50 unless you get that really unique one where there's some really good evidence and you know it really is worth you know, giving it a try. But do the majority of roundabout cases settle 50-50?
Steve, I couldn't sort of give you an answer in terms of what happens in the majority of cases, but what I can say is, and you're quite right, roundabout cases are sort of an animal of their own. What I will say is, and it sometimes can be a bit laborious, but the highway code, I cannot underestimate how important the highway code is, particularly in roundabout cases, because, and also, and forgive me, I'm not probably answering your question exactly, but I hope this helps in any event, is highway code and also Google Street View. So when preparing a case or having a look at a case, and I do this as sort of part of my preparation, is I go onto Google Street View and I find because you can, as you probably know this, but you can find the year, and it might not give you the exact month, but I go to the most appropriate month and year, and I have a look at the road markings, and I have a look at the signs on approach to the give way of the roundabout. And then I have a look at the highway code, and I bear in mind all the positions, or most likely two positions of the two vehicles. And that can often be very illuminative as to what way your case may go, or hopefully what a barrister, if it gets that far, will be able to persuade a judge of. Because sometimes you may have scenarios where, for instance, both are in the wrong lanes. Like in the, and hopefully you may have seen that one, Steve, in the one that we did, both were basically were not doing what they ought to have done. Hence the 50-50. But in some cases, sometimes you can get a bit of a golden arrow and you can see, well, actually, when you look at the street view and the road markings and the road signs, it will illuminate and tell you that actually that person was in the wrong lane for their intended exit. So that is a little bit of a tip. But as I say, sometimes you get scenarios where maybe neither are doing particularly anything wrong, or sometimes both are doing something wrong. And I accept often in, you know, roundabouts, as I say, are an animal of their own, and you can often result in a 50-50 outcome. But I couldn't tell you a percentage.
No.
Tom and Darren may have a different view to me on it, or have something to add. Tom, Darren, is there anything that
I mean, would you say that in the majority, you know, there is a much larger proportion of claims that settle 50-50 than cases that go in favour of one or the other?
I'm going to leave the word settlement out of it, because obviously often my involvement is at the point at which trial, which you may settle at trial door. to be honest, I'm trying to recall in my own experience. I've certainly had, from the top of my head, a split liability decision in a number of roundabout cases. Sometimes it might not be 50-50.
Yeah.
Tom, Darren, what?
I think I would agree that liability splits are very common in roundabout cases. There's a case from the Court of Appeal called Grace and Tanner that always gets wheeled out for roundabout cases. That was where a car was in the outside lane, motorbike inside lane, car sailed across the exit the motorbike wanted to take, and the Court of Appeal decided that was a 50-50 case. I actually personally don't think that's a great decision, but far be it from me to criticise the Court of Appeal. But that is why 50-50 is often a common starting point, because although you might say the car driver in that particular case feels more at fault because she was in the wrong lane going across an exit, it still went that way. In terms of my experience of what judges decide, I wouldn't say 50-50 is necessarily the most common. I think if somebody if someone can be proven to be in the wrong lane, then I would think your starting point should be they're going to carry more of the blame. What's going to be levelled at the other party is, well, you should have been alive to the possibility that someone might be in the wrong lane. Yeah. But to me, I don't think there's as much fault there as there is to the person who is in the wrong lane to start with. But that's just my take on it. Darren, I don't know if you have a different feeling on it.
Not really. I think I'd probably echo or reflect both what you and Hetty have said. And in fact, I was sitting as a deputy probably 2 months ago in Telford on a roundabout case where on the paper, I read both statements, looked at the photographs, and couldn't understand why on earth I was being bothered with this, because it seemed to me it had 50-50 written all over it. However, within 10 minutes of the defendant being cross-examined, I knew it was all over, because as much as the statement had been very legalised to make it sound like she knew what she was doing, she patently didn't have a clue about the discipline around that roundabout. She didn't know what lane she was. She didn't understand which exit she was meant to be taking. So I accept when you're talking about compromising claims, it's difficult, because on the documentary evidence, it probably will look like a 50-50, but you'll be amazed once you get to court. I think it's really reflecting what Hetty said, that what really becomes important is where they were intending to go, what lane they entered, what lane they exited, where the accident occurred, and that can change the scenario completely.
Okay, thank you all.
Just sorry, it's kind of a bit of a general one, because there was quite a few of the scenarios where with the witness statements, some of them started, as I've seen a lot of times, where it's kind of got the I don't drink alcohol, I haven't, or I've last drunk however many days before the accident, and I wear glasses for this, that and the other, and whatever. And then some of them just literally went straight into, this is what happened in the accident. Is there any kind of difference in how those kind of the two types of statements would be viewed in front of a judge at a hearing?
Can
I mean,
this one? Sorry.
Sorry, no, Darren. Yes, sorry.
A personal bugbear of mine. The night I haven't drunk for 7 days before, and I was watching Netflix the night before. So what? None of that is relevant. I think the court, they glaze over. They probably flick straight to the second page and get to where the fuse is lit. The only thing the court's interested in is what happened on the factual matrix of that accident on that day, or what the injuries claimed. They don't care about all the other stuff. So personally, I think all you're doing is irritating the life out of the court. This could be just me, actually. I don't know if I'm just, but my view is avoid it, get straight to the point. That's what the court's interested in. Sorry, Hetty.
No, I totally agree. That was all. I just said exactly the same.
I agree as well. I mean, put it this way, as at trial, if I see a witness statement from a claimant that doesn't say anything about glasses or drinking, I don't think I've ever thought, oh, maybe they've missed that out because they weren't wearing their glasses or they were blind drunk at the time. You don't pay any attention to it. It's just filler. So no, I wouldn't bother including it or taking any issue with it if it's not included by the other side.
Agreed. And if you all notice that nobody's ever in a rush as well.
Thank you for that. It was just seeing the two very different.
No,
I was like, oh.
no, yeah, yeah. Sorry, I think I drafted those. No, I think, but hence what I was going to say, Ruth, is because it is just really the key is what happened in terms of post-accident. Sometimes there's a lot of detail about that. It can be very relevant. Sometimes it's not so relevant. So kind of just keep it tight to really what's important. You know, what they had for dinner that night after the accident. You know, sometimes I've seen some that just, you know, it's just excessive in terms of the time period that goes on in terms of being described in the witness statement. So keeping that tight, but if it's relevant, of course, include it, and it can be very relevant. But yeah, and sorry, just while I'm digressing slightly, but it's sort of in tandem with witness statements. Another thing is, and I've had this before, is make sure that any photograph, well, first of all, ask whether any photographs are taken. And if they were taken, even if they're a slightly different angle, whatever, and there's 20, get all of them. And make sure that the solicitors have them, if you are involving solicitors at that point, or you are the solicitor, that they are included with the witness statement. Because the amount of times I've got to court and someone has said, whether it's someone I'm representing or otherwise, is, well, I took 10 photos, I sent them, I don't know why they're not here. And they can be so important, plus they're disclosable. So yeah, that's sorry, that's sort of I digress a bit, but that's something I really, really emphasize.
I think building on that point as well, Hetty, ask about dash cams, because a lot of people have them now and they can be incredibly useful. I had a case this week where dash cam footage came out of the woodwork at the last minute. It was a low velocity case, and although it was the dash cam for the claimant, so we didn't see the driver from the rear, you could hear the noise of the impact, you could see the level of force, and it's the best evidence in the case, frankly. So do ask about those.
Yeah, I agree. In terms of dash cam and photographic evidence of the locus or the damage, well, that's the only truly independent evidence in the case. So it's inevitably important. And while we're dealing with witness statements, I know there was a question about what our views were on statements of truth in terms of style and detail. Well, I think we can deal with this quite quickly. There is no discretion. It is set out clearly in the CPR in a prescribed format, and it has to be followed. You can find it, I think it's paragraph 2.1 of practice direction 22, but there is no discretion. You have to follow it word for word.
Yeah, and building upon what Darren said, I don't know how many of you have used the Holly platform that we designed at HF, but that has within it the exact statement of truth set out, and it's also got a box which you can populate the characters in, so as to ensure that you're complying with the requirements set out insofar as the OIC is concerned. So that's a really important point. And separately, I'm very happy to sort of deliver some sort of bespoke training on securing witness statements and best practice. I agree. I think it was Darren or Tom that said witness statements, you know, you don't want to simply sort of take them over an email or a chat bot. I think that to get on the phone is always important and have that blended approach to securing witness statements, and always get on the front foot, because all of the sort of contemporaneous evidence that is available at the beginning of the case doesn't always survive. There's various reasons later into the life of an action. So a lot of the time, the stuff that the sort of investigations and inquiries that you're all undertaking at the beginning of the case are some of the most crucial insofar as gathering that material evidence is concerned. Back over to counsel now.
Okay, I know there was a question talking about what type of evidence influences judges. My view on this is all about context. It depends on the type of case. So for example, if it's a personal injury case where there are concerns about causation, potentially fundamental dishonesty, well then as a judge, you're really looking at, first of all, your impression of the witness in the witness box, but then looking what documentary evidence either corroborates what the witness is saying or undermines what the witness is saying. So in terms of corroboration, you'll be looking, of course, at the medical report, whether they went to the GP, whether they've had physio, whether there's a witness statement from their partner or from their employer to say, I saw them after this terrible injury, struggling with A, B, C, and so forth. But to consider that in context. So, well, did they go to the GP before or after the instructed solicitors to intimate the claim for injury? Did they go to physio off their own back, or were they referred by a GP? Or was it a solicitor's intervention that sent them off for physiotherapy? And of course, looking at the people that have given evidence, the partners in support. And in terms of what undermines their evidence, what's key in these cases and what influences judges absolutely clearly is consistency or absence of inconsistency, so inconsistent evidence. So whether the claimant has been consistent between the oral evidence and the documentary evidence. So in terms of when they first became aware of an injury, the duration of injury, what injuries they suffered, the reasons for going physiotherapy, how long it took them to intimate their claim. It's endless, it can go on. And throwing that all in the balance and then taking those three things, the impression of the witness, whether the evidence corroborates what they're saying or whether it undermines what they're saying, and then determining whether they've proved their case, bearing in mind, of course, where the legal burden lies. So, of course, in terms of proving they're injured, well, the claimant always bears the legal burden. In terms of proving that it is a fundamentally dishonest claim, well, now the defendant bears the legal burden, albeit it's the same standard of proof in terms of a balance of probabilities. If it's a running down action, a road traffic accident, of course, it's a different scenario. You're looking there, if there's no counterclaim, then there's only one claim, and the claimant has to prove his claim. And you're looking for impression of the witness, but also the truly independent evidence, as we talked about, in terms of whether it's dash cam footage, photographic evidence, and so forth. I don't know if anybody else has got anything to add to that.
I think in terms of experience sort of day-to-day running FD trials, Darren's absolutely right, inconsistency counts. There's cases you've probably heard of called Richards and Morris and Melody, where there are a couple of paragraphs that set out very specifically the points that judges should be alive to in these kinds of cases. And I think in terms of knockout points, it's stuff like failure to disclose relevant medical history to an expert. So if you get the records that show the person's had neck pain on and off for the prior 2 years, but they haven't told the expert, that's a really easy point for a judge to latch onto and say, well, this person hasn't been truthful to the expert. Inconsistency in terms of description of the injuries, duration of injuries, anything like that. One of the points mentioned in the cases is whether that person has gone to seek medical advice. So if they haven't been to the GP, if they haven't been to the hospital, we as counsel can say to the judge, well, look, here's the paragraph in Richards that tells you should be expecting this. And claimants will normally say, well, you know, it wasn't that bad, or I know there's nothing the doctor can do for me with whiplash. It doesn't really matter what their answer is. The fact is they're not ticking those boxes under Richards and Morris. So all of those points, you know, the more you can build up, the stronger the case becomes.
With the medical attention and treatment, physio, GP, A&E, is COVID being accepted as a reasonable excuse not to have attended, you know, some of these things? You know, do judges go, well, actually, yeah, it's COVID, therefore we'll let them off for not going to the doctor? Or would they still reasonably expect somebody to have gone if they are in pain?
It's an interesting question. I have to say, personally, I've never had that as an answer to why somebody didn't go to the doctor. I don't know if Darren or Hetty have experience of that.
I haven't. I have to say, though, if I was sitting and somebody, it would depend on the factual matrix. If you've got somebody who says, I had a soft tissue injury that caused me very minor pain in the neck for a period of 2 weeks, then I wouldn't have expected them to rush off to A&E. However, if they're coming to court saying, I've had pain for the 18 months of the pandemic, so therefore I couldn't get to the doctor, I couldn't go to a walk-in centre, or you could pick up the telephone, you can speak to them. You could even have physiotherapy remotely now, although I've got some. So I wouldn't accept that as much of an excuse, I have to say. If you're in that much pain for that period of time, most people in that position, I would expect, would get medical intervention of some form.
Okay.
Yeah, no, I totally agree. And I think there was a question about this, actually, about the physiotherapy and whether it's a sustainable head of loss long term. I think that question may have been in relation to beyond COVID. pandemic, but I don't know. But I think in terms of any remote physiotherapy, one has to ask why it is remote. If it was remote because it was, last March when we all went into lockdown, then it's probably a good reason, and also something that's likely to succeed if the claim succeeds. But if, in terms of going forward, if someone was post-pandemic having remote physiotherapy, one would have to ask again why, because are they not wanting to go physically to a physiotherapist because they don't want anyone actually examining them and realizing there's actually nothing wrong with them? So it might be a sustainable head of loss, but I think it depends why. And just, I think this is something James raised just whilst we're on the topic of FD, and it sort of plays into what we've been talking about, is it's obviously not just about the injuries. It's also, in terms of FD can be found in relation to liability as well. So often, I'm sure Darren and Tom have had this frequently, where a judge, says, and quite rightly, but says, I find that neither party was lying. I just find that, X has got it wrong. But that's not always the case. It could be, and it's perfectly arguable if the evidence is there, that there is someone lying, and that may be the claimant. And I have succeeded by way of example, on a liability FD case where the judge found that when I say liability, the accident circumstances effectively on more than one occasion, which I'm sure Tom saying, which plays into causation, but it's also about accident details as well, as that go beyond just causation in terms of what actually happened, in terms of who went into who and so on. So you're not just restricted, but basically what I'm saying, by looking for FD in terms of the medical evidence. It's also in the accident circumstances. It's also in the special damages evidence. And also something that I've had as well, which is a bit more out the box, but obviously is commonplace, is also looking for things in terms of injury, not just medical records, which of course are your crucial place to look, but also social media, and social media that can even extend to things like Strava, which is basically sort of an exercise app, or social media. And someone might have a public account, so they might have told the expert, I couldn't exercise for 6 months because I was so injured. And then you get their Strava account and they've been exercising every single day, doing 20-mile runs every day. So sometimes you do really have to think outside the box, and it's not just about the medical records, and it's not just about the injuries. It can also be about the accident itself.
Yeah, I agree once again. I think in essence, Hetty's saying that in terms of if you've got a claimant who we are fighting the cause of the accident, so breach is in dispute, you've also got issues of causation of injury. Even if the causation element and a claimant is wholly consistent throughout, but he's so inconsistent on the cause of the accident, well, that credibility, in my view, runs right through the case. If you can't believe a word they're saying about the accident, and it's a bit more than they're just mistaken, in fact they're lying, well, how can you be satisfied that they were injured? Because there's no objective way of knowing if somebody suffered a soft tissue injury, unless there's an MRI, for example. It boils down to the veracity of the claimant when they're medically examined. So I agree completely, the credibility runs right through. And in relation to the physiotherapy, I don't think this is sustainable post getting out of this pandemic at all, because you need, on physiotherapy, you need a physical manipulation to see their range of movement, their reaction in terms of palpation, because otherwise how long do you know they need physiotherapy for? I mean, you may as well send them off to YouTube and then they just watch a clip and they charge 500 quid for that. It's absurd. It seems to me that there has to be going back to physical manipulations. Otherwise, even medical experts could say, well, I don't need to physically manipulate them in an examination. I can just do it by video. It's just not sustainable, in my view, in the long run.
I think Adam and Steve, it's probably fair to say that resonates well with Ageas insofar as the comments with regards to remote physio is concerned, because I know that that's a battleground that is quite hot at the moment. What sort of success is Ageas seeing? Are these arguments well received generally post I mean, before the files come to us? I mean, we certainly have been able to knock out quite a few of them.
So we had a mixed result in terms of our strategy. So at the start of the pandemic, it was no, it was always no, we're not making any offers, we're not agreeing to anything. And we found that some of our opponents constantly just turned around and accepted it. They weren't up for the fight, they take those nil results. As the pandemic seemed to last longer and longer, we found more and more opposition from the other side saying no, you know, it's a reasonable expectation because of the current situation. And when we were finding a lot of these cases predominantly go into, you know, stage 3 MOJ hearings, that judges with their limited time frames and stuff like that were on the fence saying no, you know, that this is a once in a lifetime situation. Unfortunately, the pandemic dictates everything. You are, you know, up the creek without a paddle. So we were finding it was just constant. It was loss after loss after loss at stage 3. So we've adapted our procedure, and we've almost got like a red, amber, green situation depending on when these cases are being undertaken. So if we've got cases where it's happened during pure lockdown, all the treatment's been undertaken while everyone was under the quash, it's a case of it's red, compromise, try and get a settlement as best you can, but use evidence and support to say some agents were open offering face-to-face at, you know, a particular rate, or we were still able to offer face-to-face treatment for £35. Therefore, you know, we'll compromise and offer you 30 pounds a session, because if we can offer it face-to-face, why does a remote session cost us £55? Or even before the pandemic, why is it £55 but remote is now 55? Surely there should be a difference. And we found that judges were more receptive to those type of ones, even during the pandemic, is to say, you're right, you know, a £55 a session for a remote one is ludicrous, it's way too high. They were almost halving these rates in half. We thought, brilliant, if we're offering 25, £30, that works for us. But it's a case of now we're kind of in the situation as we see newer cases post-March where lockdowns have seeming to be lifted, and, you know, as per the government advice from Monday, we'll see no social distancing restriction any further. Those cases are more to the point where we're kind of going back to our no offer, but on a counterpoint, kind of bolstering our arguments rather than just saying no, it's, you know, this is unsustainable, there's no reason why it shouldn't happen, but also looking at where the agencies are. You know, okay, you're doing remote, but this person was open to offer face-to-face. Why would this person specifically choose remote as opposed to hands-on? Or on some cases we've seen this person was assessed by someone who lives 200 miles away from where they live. This was clearly never going to be anything other than remote. Or if they've, you know, accepted a hire car, they've used a vehicle during the pandemic process or during the current thing, they've got a hire car, they're still going to work, and, you know, they're seeing the public day to day, just to kind of not steer judges but give them a reason, as I'm sure Darren will probably attest to, is saying, here's the evidence to support why you can agree with us that a nil offer should be made, and trying to put our best foot forward to say, here's a reason why you may agree, rather than saying, I agree, it's probably ludicrous and shouldn't be happening, you know, now 4 months after lockdown is ended, but I've got no reason, unfortunately, to discount it, no additional rates evidence or no evidence to say they were open or able to do this sort of stuff. So it's a long process, I think, for our guys, and not something we don't take as gospel that's easy for them to do. We're asking them to do a lot more, but yeah, hopefully we start to see the results come through slowly.
I was going to say, Adam, just on that point, and this is just something, I think there's been a couple of questions about the MOJ in the portal, and it sounds like this is what you guys are doing anyway, but just in terms of some experience in terms of stage 3s that I used to do quite frequently is, if you've got any evidence of, you know, well, actually, you know, this physiotherapist was open and this person wasn't vulnerable and they could have gone, or actually you could have gone to a physiotherapist down the road instead of 200 miles away if they did go in person, and then they're claiming ridiculous travel expenses as a result, is obviously just making sure that everything is uploaded at stage 2, because sometimes what happens is we get instructions to make these points, and as I'm sure you've probably encountered before, if then the judge is like, well, I hear what you're saying, but I don't have any evidence to support that. Or, yes, you're bringing it today, but it wasn't uploaded at stage 2, so I'm not going to consider it. So that's just sort of a general sort of not tip, but, problem sometimes that can be encountered. So yeah, the more evidence, the better with things like that. As much as it's a real task for you guys in terms of collating it, or the solicitors, it really does help. In terms of just on the FD questions as well, I think Darren was going to cover a couple of these, or Tom as well, but I think I was just looking, there was a question about finding on versions that seem implausible. I think we've covered that really now about, are the accident circumstances actually, can a claimant prove that they're more likely than not to have happened in the way they say they happened? And that also goes back to the point about photographs and dash cam, and also the question about the best contemporaneous evidence. Photographs or dash cam footage can be, the difference between winning and losing, and also an FD finding or no FD finding in relation to that. But in terms of other contemporaneous evidence, we've also touched on obviously seeking medical attention. But the other thing I'll say in terms of that is, again, it's not just about, okay, they went to the GP, so they've ticked that box, which Tom quite rightly says is something that judges look at and counsel. It's also about what did they report. And sorry, this also ties in with the question about whether version of events is implausible or not. Is sometimes what I've had or seen before as well is, okay, they go to the GP, but they actually give a different version of events. So they might say, I don't know, head-on collision, and then they're claiming that actually it was a rear end shunt or whatever it may be. They can sometimes give a different version of events to the medical practitioner. And also, again, going back to the injuries, they might say to the doctor, I've hurt my neck, but then they're subsequently claiming neck, back, shoulder, elbow, leg. So really, they can be obviously tiny writing, and it takes forever sometimes to go through the medical records. But rather than just, I'm not suggesting anyone does this, but just saying, oh, they went to GP, really look, what did they tell that GP or that nurse? Because that can be crucial as well.
I think, sorry, Hetty, if I can just jump in.
No, please, Tom, yeah.
Something as well that even better than them not having been to the GP about the accident is if during the prognosis period they've been to the GP about something else and not mentioned the accident, because then you can go a step further and say, well, you were there anyway. Why didn't you mention this severe neck injury that you claim you suffered 2 weeks before? And I think that can be really powerful. And you can also look at the history. If there's someone who goes to the GP every week, for every single problem under the sun, it's going to make it that much more unlikely that they would fail to go if they'd suffered a serious neck injury. So it's not just about whether there was an appointment for the accident, it's about what's going on more generally as well. So I think that's always worth looking for in the medical records. I appreciate you guys at Ageas may not necessarily have the medical records at the stage that the files come to you, but it's definitely something to be aware of and make sure James and his colleagues are on top of as well. James, I imagine you and your guys are on top of all of this, and look at those records as early as you can.
Yeah, absolutely. And it's always something that will form the basis of instructions for yourself and your colleagues at 3DB. We'll look to sort of summarise those, identifying consistencies and points that Tom just mentioned. So yeah, absolutely, it's about quality but also quantity. You're not missing anything out, and sort of going through it with as forensic a tooth comb as possible, really, to try and catch them out if possible, for want of a better phrase.
And can I just add to that, because while we're on this point, because the GP records can be absolute gold dust in these cases, not just only in relation to what's been covered by Tom and Hetty in relation to previous constitutional problems that they've not declared, but also in terms of what they did tell the GP when they went, as Tom said, and also what they didn't tell the GP when they were there. But what really frustrates me sometimes, though, we get the GP records sent off by the claimant to the orthopod or the GP, and they say, so they won't disclose them. Then they say, well, no, the medical officer has read them, you don't need to see them. Yes, we do, because the amount of times that an orthopod or a GP has missed critical evidence, because the reality is they've got half a dozen of these cases in a week they're looking at. They don't go through these records in the same way we will, or the solicitors will. And therefore, in my view, is no, they're still disclosable documents. And if you don't make an application, let's get those records, because I guarantee they've missed something.
Yeah, no, I agree with Darren entirely. And, we were always, when we're filing our directions questionnaires at the stage when the DQs are due, we're always saying, we want full disclosure of GP, hospital, maybe even occupational health, employment records if it's, you've got serious concerns about this case. And if after that, we're not satisfied that full disclosure has taken place, the lawyers from HF will seek instructions from Ageas to make an application for specific disclosure on the terms set out by Darren and for the reasons set out by Darren. So yeah, absolutely.
I think there was a question about why we're dealing with FD and so forth about Section 57. And I know there's always a lot of confusion about Section 57, but there really shouldn't be. It's actually relatively straightforward. If the case is dismissed, Section 57 plays no part at all. If there's concerns about FD, you're straight into the CPR, it's 4416, simple as that. If, however, the claimant succeeds to any extent, don't worry whether it's a primary or a secondary claim, any extent, it's Section 57. At that point, you're saying, right, even though they were right, or you found they were correct on an element of the claim, they've lied about everything else. Dismiss all of it. And to give you an example, I think it was a HF case not long after the 2015 Act came in. I think it was around 2016. I think there were 3 claimants, all claiming PI for around 18 months with splashes. The judge found, wrongly in my view, that, well, correct to this extent, he wouldn't accept that they'd suffered an 18-month injury. And bear in mind this, at the point when they went to see the medical expert, which was around 8 to 9 months, they were saying, I'm still injured, having all these problems, no progress. The judge found he wouldn't accept their evidence because they were so inconsistent that they sustained injury for 18 months, but he found that they'd sustained injury for 6 weeks and then gave them, I don't know what it was, I can't recall the figures now, but let's say it was £1,000 each. So that meant on the court's own findings of fact, at the point when they saw the medical expert, they were lying because they weren't injured. That's when Section 57 comes in and we got the whole lot dismissed. There are obviously other scenarios for Section 57 if the claimant supported a bogus passenger, for example. I'm sure there are let's say it's a genuine injury, but they're also then making a fraudulent claim for care, fabricating invoices, or even saying a family member helped when they didn't. That's all Section 57 as well.
One of the things that we routinely look at and challenge is the differences between what was advised at CNF stage versus what we get through in the medical report. So if the CNF says, neck, and it was submitted 3 or 4 weeks after the accident, i.e. in plenty of time to know what their injuries would have been, and then the medical evidence comes through and it's neck, shoulder, back, left knee, do judges view that as because we see the CNF as a statement of truth, but do they see it as really quite critical, or do they think, oh, it could just be, somebody's completed it inaccurately initially? I mean, is there sort of some credence put to that? Or
there's been an absolute sea change in the use of CNF since Melody and Richards. It should have always been the case because it's always had the statement of truth and it's always been part of the claimant's case. Albeit I accept, of course, it's normally completed by solicitors, but it's only completed by them following information provided by the claimant or written somewhere else by the claimant. So if they're saying something inconsistent, this was always part of their case. Now, it used to be the case where a lot of judges would say, well, I've got other documents, I'm not sure that particularly helps you, he didn't fill that document out. But since the High Court case of Melody, I've seen a real sea change. And now, because of course the judge was absolutely right, these documents are capable of being used in contempt proceedings. So of course they're relevant. Now, I think judges of all kinds throughout the county court look at these documents, CNFs, really, really carefully. And I think that's become clear to claimant solicitors, hence the reason they are quite reluctant now to enter them into the trial bundles. Hence the reason you've got to chase them and get them in there.
Thank you.
Sorry, just on a kind of linked point, if you don't mind, we see a lot of CNFs and solicitors where they literally just put something like, our client has, they've ticked the whiplash box and the soft tissue box. They've said nothing else about the actual areas of body that were injured, and they just say, we'll provide more information when we get the medical evidence. Is there any way the court views that?
It wouldn't be as strong, but if I was defending counsel, then I would be saying, well, I'm going to invite you to draw the inference. At that point in time, it's the most contemporaneous document we have. They know exactly what injuries they've suffered. It's the nearest point in time to the injury. They know exactly what they're suffering and to what degree. If they were saying they're suffering severe pain for the first 3 weeks, well, surely that would be detailed in there. They'd want everybody to know about that, the defendant, the court, and so forth. So I wouldn't say it will be a killer point, but it seems to me that you can say, I invite the court to make an adverse inference by the fact they wouldn't give us clear details. That's my view. I don't know whether Hetty or Tom have a different view.
I was just going to say, forgive me, everyone. I'm actually just been emailed to see if I can start a hearing early, which is quite unusual. So I'm sure you won't mind if I leave at this juncture, but just to say thank you so much. And if anyone wants to drop me an email about anything, my email is on the website of 3PB. Thanks, Darren. Thanks, Tom. Apologies, everyone.
Thank you.
Thank you.
Good luck at the hearing.
Thanks. Bye.
Thank you. Picking up on the CNFs, I agree with what Darren has said, and I think day to day on the ground, particularly in front of district judges, you will still get district judges who perhaps aren't that experienced with FD type work, and their initial reaction is to say, well, Mr. Webb, the claimant tells me he didn't read this form. You know, really, is there that much weight to be placed on it? And that's when you say to the judge, well, yes, actually, High Court guidance is you must place weight on it. You can't simply discount it. So it's very difficult for claimants to wriggle out of it if there's something pretty damning in the CNF. And I think aside from the description of injuries, the common errors are about whether they've taken time off or not, and whether they've sought medical attention or not. Those are quite often wrong as well. If, despite referring the judge to authority, they still, in their judgment, decide the CNF isn't of any weight, then obviously you've got a decision to take about whether to appeal it or not. You may well have a fair chance on appeal, but obviously you've got to decide whether commercially it's worth it. But as a broad headline point, yes, CNFs are important, and they are one of our best points at trial at the moment.
Yeah, I would echo absolutely what Tom and Darren said, and indeed, one of the things that we check as sort of supervisors and what have you at HF are these trial bundles, because it's remarkable the amount of occasions when a CNF is just omitted from a proposed trial bundle, and it's the biggest indication for me anyway, or one of the big indicators that the claimant solicitor is quite concerned. And we always obviously go back and say, no, CNF's going in because it undermines your client's claim. So, but you'll often see that just, missed off of the proposed trial bundle.
Yeah, and again, the importance, I think it dawns on claimant solicitors, because it also gives us the date. If they did go to the GP, you normally find they went to the solicitors first, then they go to the GP, or they do it on the same day. And that gives you an indication. And also in terms of physiotherapy, because again, the Melody case tells us, well, they really should be going off to physio themselves or a referral from the GP. It really shouldn't be solicitor's intervention. Now, I'm sure claimant solicitors say, well, all we're trying to do is help them mitigate loss. No, you're not. You're helping them bolster their case. And that's the reality of it. And you'll see in the CNF, the section where it says, is there been an assessment of a need for rehab? And often it's ticked no, but then they've gone off for physio. So you know it's the solicitors that have sent them off for physio. So you can say to the court quite clearly, take an inference from this. This wasn't because they needed it, because they would have done it themselves. They would have gone to the GP. They did it because the solicitors have pointed them in that direction, And I think that plays well with the court as well. So I can't get over the importance of the CNF and how often claimant solicitors try to, nothing worse than opening a trial bundle and not seeing the CNF, it drives you up the wall. It doesn't happen often because solicitors are switched onto this, but it does happen occasionally, and they're really important documents.
We even have a trigger in our case management system that goes to sort of senior supervisors before the trial bundle gets approved to check that various documents are in there. So your cases would never go to trial without the CNFs in there, basically, because of those safeguards. And I think probably more generally, one of the things that I think Ageas does really well is that I think it's probably fair to say that your teams are almost multifaceted in terms of they're considering fraud, they're considering wide-ranging sort of credibility issues, and you don't handle your cases in very, I suppose, closed departments. So you're not screening fraud from the rooftops in every case, but equally, if it's not a non-fraud team, you're not sort of discounting that. And I think that's absolutely the way to go, because you can secure these sorts of findings that Darren and Tom are talking about, even on cases which, on the face of it, when they land on your desks, aren't fully blown fraud cases. They were talking earlier on about instances where you can secure a finding of FD when, the claimant's advancing a factual liability set that's just so palpably far from the truth, so as to be tantamount to dishonesty. So always worth, having a real sort of mindful approach to these types of cases. Hand back over to the group now.
I think in terms of the listed written questions that I've seen, I think we've probably covered all of them. Somebody will point out if I've missed one. So I don't know if there are any more general questions.
May I ask a question about a scenario that you had with a bus and a motorcyclist going across the 2 lanes of traffic when the bus stopped? Although in theory, I kind of felt that's how the case should be, dealt with, that the car driver did nothing wrong. But at the same time, if I was handling this claim and we were insuring that driver, I would be extremely wary going all the way to trial, because I was just surprised that I've always felt that if we have a motorcyclist or if we have a pedestrian, that because they are more vulnerable on the road compared to the driver of the car, and they would normally sustain more visual injuries or sometimes quite serious injuries, that the court would kind of lean towards and will try to award them something. So I was extremely surprised that there was no like 10 or 20% to the motorcyclist. So I don't know, is the extent of injury as well would kind of would have an impact on a judge, because a judge is a human being and he can see a compensator on one side. And yeah,
I get the point, because at the end of the day, judges are the same as everybody else. They're emotional beings to a point. However, as lawyers, as judges, you're trained very differently to think very differently, and experience does that to you. So you can have all the sympathy in the world for somebody that's been knocked off a motorbike or a child that's run out in front of the bus, but that's not the question. The question is, has the defendant been negligent? Now, on that scenario, if you recall, I think in cross-examination, the question was, you should have stopped. Well, no, I shouldn't. I didn't have to. Or worse to that effect. Well, of course you do. You're cutting across an obstruction knowing there's an inside lane where traffic's going to be flowing. What was the negligence of the defendant in that scenario? She's entitled to continue forward. She has to be aware of her surroundings. There's a junction to the left, an obstruction to the right, and a possibility of something coming through. But the evidence was that she was probably going no more than 15 miles an hour. So there was no negligence at all on her part. The time difference between when she pulled out and the accident was so small that she had to be in there. So in other words, the claimant didn't look. However, taking your point further, if the evidence had been, however, that she still pulled out without looking, clearly some contributory negligence. However, or she looked, but the defendant wasn't there from as far as she could see, because the defendant was traveling so fast. Let's say the defendant had been traveling 50, 60 miles an hour, knowing there's a junction on the left, knowing there's an obstruction on the right, and the possibility of a motorcycle or a child or whatever coming across, inevitably there would have been negligence against the defendant, and possibly some contributory negligence against the claimant. But on the factual matrix of that case, there was no evidence that could surmount or equal to a negligence finding against the defendant. I understand what you're saying about the emotional impact the courts, but I think you've got to give the court a little bit more credit in terms of they are used, obviously with accidents, people get hurt. And a lot of the time, unfortunately, motorbikes, there is never a minor accident with a motorbike. Because if you come off a motorbike, you're getting hurt. It's as simple as that. It's not the same as a car. And if a child runs out in front of a car, they're going to get seriously hurt. So the courts are used to this, but they look at the evidence. Then first they identify the issues, then they look at the evidence, then they make the determination. And the emotional side isn't really going to be a factor, not in my view.
Yeah, I would agree. I think to an extent, any road traffic claim is a bit of a lottery because things come out in the evidence at trial that might change the perspective, or, you know, some of the evidence judges can just interpret things in different ways. So I think it's always right to have a certain degree of caution about your cases and never to assume you've got an absolute guaranteed winner. But in terms of whether a judge is naturally going to be more sympathetic to somebody on a motorbike or a bicycle, I don't think so. Not in my experience. There might be the judges that are outliers that are particularly claimant or defendant friendly, but they're pretty rare these days, I would say.
And in fact, I have actually dismissed a case where there was a pedestrian. He wasn't a child, and he was an elderly gentleman who just stepped out. And I felt nothing but sympathy for this guy because he was quite badly injured, but it wasn't the fault of the road. She was just driving along quite properly, and he stepped out. I had nothing but sympathy, but that sympathy was, my sympathy is no good to him. It's on the evidence, was the defendant liable, and plainly not. But you can appeal me if you want on scenario 4.
One of the things I found when I went through the video was the interesting one was the dash cam footage, the fact that she didn't disclose the footage, stated she had footage which would have clearly exonerated her had she correctly proceeded on a green light, as she alleges, or as we dispute, saying it was red. But on that type of case, if we know there is evidence that is not being disclosed, or we have a strong suspicion that evidence is not being disclosed, how is it best to approach that? Do we wait until trial under cross-examination and ask the question and to have our barristers prepared to turn around and say, we put to you that you had this available in your car, and wait for them to kind of hang themselves? Or do we put this in questions beforehand, but almost giving them the chance to preempt this at trial and almost like give themselves an out at a later point?
Well, in modern litigation, you can't sit on your hands and you can't ambush. It was different prior to 98. My view is you've got to be proactive. You've got to say, we know you've got something, you're not disclosing it, you have a duty to disclose, you're failing to do so, or we make the application. If you then make the application, it'll be determined one way or the other, but you can still use that at trial. Well, why didn't you disclose it? What were you hiding? Well, we know why, because here it is. So in my views, no, you can't just sit there and then wait till trial and then say, aha, you've got to do more than that. That's my view.
I agree. And one point I'll add before, I don't know if Tom would have anything else to say on that, is Adam and everyone in Ageas absolutely get that in writing, continue to advance those entirely reasonable requests, because that helps us as lawyers nail them on these applications, because we will annex all of that to the witness statements in support of the application for specific disclosure. It depends upon what you're asking for as to when we can ask for that. I don't know, Darren and Tom might have some views about applications for things such as GP records before the court's ordered DQs be due and disclosure thereafter, but paper trail helps us enormously to succeed with these applications in conjunction with counsel.
It's nice to hear, because you'll see it on cases you probably see from us, but it's constant from us. We'll request evidence from the other side because we believe it's available and it's there, but it does seem that we get stonewalled
Yeah.
A lot of the time, obviously pre-trial, and the constant response is, we're at no liberty to have to disclose this to you until witness exchange and all this sort of stuff. And you think, well, what more are we able to do? But as long as, by the sounds of it, we are, by making those requests early doors, that is the best way for us to do everything we can do, at the trial, then that's fine. It's just a process. Yeah.
Absolutely. It slightly depends upon what you're asking for as to whether that application will be successful at earlier stages, but absolutely keep those paper trails up. And also, there's an opportunity to recover costs, because effectively the courts want to see as many cases settled pre-action as possible. That's furthering the overriding objective. And if the other side is seen not to be engaging on terms which might be expected, then absolutely, we can make those applications, and a lot of time we can nail them on costs through Ageas as well. I'll hand over to Tom now, though.
Yeah, I agree. In terms of the question of whether it's perhaps better to leave it to us to deal with it at trial. I mean, aside from what Darren said about that just isn't acceptable under the CPR anymore, there's a rule which some barristers place more weight on than others, but there's a general thought that you shouldn't ask questions if you don't know the answer, because you want to keep the witness's evidence controlled. And what you can be doing is asking us to go off down a road that actually may not take us in a good direction. If we're kind of asking speculative questions about a dash cam, the claimant might say, oh yeah, here's the footage on my phone. It shows your client smashing into my car at 25 miles an hour. So it's much better that we all know where we stand at an earlier stage. We can prep the trial in full knowledge of the evidence. So yes, I would absolutely agree. Get everything sorted before the trial. Don't take chances on leaving it to the trial advocate to deal with.
I think just picking up on that, don't ask a question you don't know the answer. I think that takes us back to bar school. There was a famous High Court case, I think he became a High Court judge about a judge that asked the question, and he really did put himself in difficulty. But it was one of the worst things they ever taught us at the bar school, because you have to ask questions you don't always know the answer to. What you have to do, though, is work out all the possible answers and make sure that you can then go on and make sure each one of those is inconsistent with something else in the evidence. So it doesn't matter what they do, they're going to be in trouble. I mean, you're as good as the evidence sometimes, but if they're lying, you're going to cast them out. In terms of disclosure, I think we've covered the point, but my view is that this stonewalling that's been mentioned by claimants solicitors is just obstructive. There is the CPR now is all about cards on the table approach. So we all know exactly what we're facing. We know what the evidence is. There should never be ambushing. So it seems to me, as long as the evidence is relevant, let's say you've had a look at the Q database and you can see he's got 1 million different accidents in the past. He's made numerous claims. Well, the GP records need to be disclosed now. Why do we need to wait till standard disclosure? At that point, we can look at them and we can see what case we have. And they can also know what case they have. It saves terms in times of cost. In that scenario, for me, if they won't play ball, you make an application. Put them on notice first that if they don't do it, we'll make the application. And if they stonewall you again, then you make the application. But I think the point's already made by James. It depends on what you're looking for, the point in time, and as Tom says, the relevance of it in the long term.
Yeah, and one point to emphasise there from a sort of the lawyer's perspective is absolutely do put them on notice. So that's going to help you have an ability to recover costs, because if you just go bang and make an application, there could be some scope for criticism there. Even though we know some of them are just never going to be forthcoming. Your bond turners or this well, for example. So it's pointless putting them on notice, but you've still got to do it. Oh, I wondered, did anyone watch one of the scenarios in particular, and when listening to the conclusion, felt really surprised about the outcome? Or did you predict all of them perfectly well?
I wasn't personally surprised, because often these things, as you know, can go sort of one of many ways. And I think we're so used to hearing outcomes that we didn't expect, or we hadn't hoped for. As somebody mentioned earlier on, sometimes you think you've got a bulletproof case, and then something comes up at trial and we lose, and we think, so I watched all of them, and I was just keen to see how they were viewed. I didn't have an expectation, to be honest with you, because I think we've had those in the past, and you know, quite rarely does it actually. I say that's not true. I mean, we obviously do get, you know, cases that we're confident about and are successful with, but you know, often there have been decisions where you can't quite sort of put your finger on that trail of thought. But then it's easy to get so sort of involved in your own claim, and sometimes it's hard to step back and see the evidence for what it is at times. I've been guilty of that myself a number of times, where you know you become so emotionally involved in it, and you can't see any other outcome other than the one that you think is, you know, the right one for you. But when you get maybe a colleague to look it over, you know, it's easier for them to stay objective.
Yeah, I agree. I think particularly so when, you know, you've got a mindset that there are particular concerns associated with the case. Out of interest, has anyone in the audience today been to see a trial before?
Yeah, I have.
Yeah, I've been to a couple.
Okay, yeah. And did they sort of play out as you thought they would? You know, was it how you thought it would be, or?
I went so long ago, so much has happened, but yeah, it was really good, and it did play out how we thought it would in the end, but I can't remember the ins and outs now, but it was really good. It was so good to see those scenarios as well, because it just brings everything, like loads of things, back to the forefront, so I really enjoyed them all.
That's good. Well, I'm glad you liked it. Well, I'll take that away with David and Ed later on. David and Ed are the practice director and practice manager respectively, and there's going to be on the horizon a bit of an offering for Ageas only, to sort of invite you guys remotely to watch some of your trials. So we'll follow that up separately, and I'll drop you an email afterwards, Adam and Steve, about that.
I think that would be great, because I was going to say that, sorry to cut across you, seeing what happens in court, you get to see what really works and what doesn't, and it becomes invaluable for the way that you're proceeding, preparing your cases going forward. Sorry, I cut across somebody then, I'm not sure who it was. Who was about to
It's okay. All I wanted to say was that I knew about cross-examination, and I did go once to a quantum only hearing, so it wasn't any like cross-examination as such. It was just more like, yeah, you attended, that's your medical report, happy with that. I knew about cross-examination, but I just wish we were able to speak to our policyholders the same way, because the way when we speak to them, it's more of kind of mess as a conversation. They just fly all over the place, and you try to bring them back and say, no, let's just talk. So you said that you stopped. Did you check your mirrors? Did you check your blind spot? And then quite often they would say things to us like, he came from nowhere. And it was amazing to see that, on one of the occasions there was saying people actually would not come from nowhere. They came from somewhere. And if you did check your blind spot, you would have seen them. And it was just that conversation that, kind of makes you, because we always try to have this conversation with our policyholders, but because they are our customers, we have to be kind of tread carefully, not to upset them too much, but we have to assess them as a witness, because we can draft a lovely statement for them, but it's them who would be in front of the judge, and if they're all over the place. So I was just interesting to see how kind of tough in a way, they had to be with them, and how they responded, and that's it quite show like what kind of witnesses they are, and that's the kind of conversation we really need to have with our policyholders before it gets litigated, because afterwards, it's just there is no point.
I get that, and you don't want to cross-examine your own policyholder, but equally you can make them understand that this may go to court, and we want to protect you as our client as much as we can and prepare you. So it may assist even yourself if you want to keep them focused, which is the difficult thing, is to, you don't have to write out a list of questions, but maybe have some bullet points in exactly the plan. Same as cross-examination, you don't really write questions, but you have a plan of where you're going, bullet points and page numbers, and you can do the same thing. This is where I really need to ask the clients about. I need to know this. And just follow through the plan and just try and keep them focused. You can do it in a polite way without making them feel intimidated or that you're against them. You make it clear you're on their side. So I get the difficult. You're in a different position to what we are, but Equally, when we get to court, we have to have a conference with the clients, but it is different because once they're at court, they already know it's signed, and they want you on the side, so then they don't take offence as easy. But so I do understand, but I think you can have a plan and explain why you're doing this and keep them on side that way.
Yeah, I agree with Darren and Kat. It's a really good question. Managing your insureds and managing them from the perspective of a witness is a real skill. It's not easy. It's one of the most challenging parts of the role, I would say. Actually, funny enough, you should say it, Kat. This morning, we were recording some material which, to our minds, it's not necessarily right or wrong, but it's our view, sort of a best practice way in which to secure witness statements, specifically for the OIC. So I'll send that across later on to Adam and Stephen. You can disseminate it. But it's about a 20-minute video, and it takes you through the stages as to how to best secure these witness statements and how to focus on asking particular closed questions and the such like. And it's geared up to helping you secure statements as within the OIC in particular.
Thank you.
A pleasure.
One question I've got, I know I asked loads, I told you not to invite me to these things, James, and this is why.
No, it's good. Go for it.
But you did mention, obviously, when it comes to section 57, obviously, if one part of the claim is dismissed, then, we can rely on that to say the entirety of the claim should be dismissed. One thing I alluded to with James yesterday when we had a conversation was how significant does that element of the claim have to be in order for us to almost secure that verdict? Because whether is a £250 recovery fee where we know they haven't had it recovered and they drove away from the scene, is that significant for us to say get rid of the whole claim, which seems very unlikely compared to a £5,000 care claim, which is clearly falsified with witness statements, documents, and all that stuff. So where would you say is the line of when that becomes?
Well, it's an excellent question. I think this is absolutely where Darren and Tom's insight will be invaluable. So I'll hand over to Darren and Tom to sort of offer their insights from the perspective of sitting.
Okay, all I was going to say is this. I don't think there's a definitive line, because you can't simply look at the value and say, well, it's only 250 quid for a recovery, so compared to the value of the PI or the credit hire, it's no big deal. Because at the end of the day, if they've claimed a recovery fee, for example, using your example, and that was a complete lie, well, first of all, it's a lie. But secondly, it's a lie in a witness statement, and a statement as a statement of truth. It was probably a lie in the CNF. It's a lie in the special damages document as well. All of them with a statement of truth, so they're significant. So it seems to me at that point, even if they're correct on everything else, if they've lied, that part of their claim is fundamentally dishonest. Now, you can say, well, it's only, 10% of the value of the claim. And I'm sure that's what claimants' counsel will say. But my view is it doesn't matter. Now, don't get me wrong. It may not be that a judge will say, absolutely, section 57, because it's only 10%. But it seems to me, when you break it down to the court, it's a lie, but it's also a contempt in terms of 3 documents with statements of truth. It becomes more significant. I think it's the way you approach it with the judge. And in that scenario, using those facts, you could persuade a judge to strike out the whole lot, even if the credit hire element was significantly high or the personal injury. But it's all dependent on each factual matrix. I'm not sure what Tom wants to add.
Yeah, I agree. I mean, the value of the dishonest element, I think if it's high value, there's a good chance it's going to be deemed fundamental. If it's low value, there's a lesser chance, but it depends on the context. I can't remember which case it is, but one of the cases refers to perhaps considerations of whether that element of the case has substantially affected the presentation of the case, so how much time has been spent on it, that kind of thing. So it may be something that's not worth much, but actually it's taken a lot of time in terms of the defendant having to prep and deal with that element. A lot of investigation might have gone into proving that it's dishonest. So I think there are lots of factors at play. I wouldn't automatically rule anything out necessarily as potentially meeting the definition, which is kind of fairly woolly guidance, I know, but I think that is basically where we're at with the law at the moment. I think another example given in the case is about a house, and you know, the walls, the ceilings, the structure of the house, they're the fundamentals. If it's a picture on the wall, that's sort of tangential and not really of interest. It's that kind of thing we're looking at. Is it one of the building blocks of the case? So, you know, one of the most famous cases was a false claim for gardening, because the whole thing was fabricated. That was fundamental. If in fact what the claimant had done was to, you know, claim for an hour extra a year instead of, you know, when they were having 10 hours anyway, that might not be so fundamental. So it's all just really dependent on the context.
Yeah, in that case that Tom's referring to, the Sinfield case, I think on the gardening, I think it was around 23% of the value of the claim, and the court found that the whole lot should go. So that gives you an idea if you're looking at percentages, although I agree with Tom, you're not really looking at just the percentages, you're looking generally at the issues. And again, even if it's only 10%, but it's a significant lie towards a significant part of the claim in terms of the element, i.e. I had a vehicle recovered. No, you didn't, you lied, and you've lied in several documents. I think that's enough personally.
Yeah, I'm with you on that, Darren. And we try to sometimes make the distinction, Adam, when we're reviewing cases internally between an outright lie, you know, the recovery point. I'd be saying absolutely nail them for that, because that's, you either did or you didn't. And then looking at embellishment. So I think Darren just gave, or Tom gave the example of maybe sort of claiming for a bit more care than you had. You know, we don't dispute that you needed care as a result of the symptoms associated with the injury, but you've embellished that to an extent. You know, that probably wouldn't be enough, and you wouldn't necessarily want to incur the costs associated with running a case of trial on that. But using your recovery example, even if it was a relatively low percentage of the entire claim, I'd be saying, look, Ageas needs to be taking a strong line on claimants who are actually lying about something. That's a factual point. You can't be mistaken about that. So yeah, if it was me, you know, I'd be saying, Ageas, HF, let's absolutely go to town with them on that. We can't let them get away with things like that, particularly when you're putting your name to a statement of truth, which says, you know, you realise that you could be a contempt of court, you could go to jail. Effectively, that's how serious it is. And I think probably everyone at Ageas would want us to take that hard line as well. I imagine there's sort of a few nods out there. I mean, I just wouldn't be letting them get away with that. You know, not at all. What's the point otherwise? You know, you might as well just settle everything.
Yeah, and I think the court's approach has hardened over the years as well. I think your chances of getting FD now is so much stronger than what it used to be, because the increase in fraudulent claims is so high now. Whether you call it fraudulent or you call it fundamentally dishonest, it means the same thing. It's all about lies. And it used to be the case years back where I think there were certain regions, particularly in the north, you did pretty well with FD, except for Liverpool. Liverpool's always been a law unto itself, which I've never understood. Although I did win once in Birkenhead. I thought they were going to build a statue of me in Birkenhead because it's such a claimant-friendly court. The southwest is particularly claimant-friendly, but London and going towards the east is more defendant. But I think there's been a complete change in that, because even judges, particularly in the southwest, who haven't seen the amount of fraudulent claims that say they do in London or Manchester, they do now, because it's such a widespread nation problem. And now they are more alive to it, and they are sick to death of it, and they are more willing to find FD, whether it be under 4416 or section 57. So my view is it's quite straightforward. If you're a claimant, tell the truth. If you're telling the truth, you've got nothing to worry about. If you're lying, if we smell blood, then we're coming for you. And I think that's how it has to be.
Yep, I'm with you all the way on that, Darren. And I think that also the good point for Ageas to sort of note, obviously your fundamental philosophy is to limit your indemnity spend, and you know, as a business, that's absolutely right. You should be doing that. But gone are the days when, you know, every fraud case is allocated to the multi-track. It's not like that anymore. So the consequences of you running an FD argument and perhaps not succeeding are no longer severe in terms of the pocket. So, you know, I'm not saying run every case where, you know, there might be an embellishment, but absolutely nail them on any case where they're lying, because you need to sort of be seen to be taking a hard line in those types of cases. And again, if you guys ever this goes for anyone in Ageas. I said to you yesterday, Adam, that if anyone ever has a question, just drop us an email, and we're going to be actually setting up. This is a bit jumping a bit ahead of myself here, but we're going to set up something for Ageas called Ask Ageas. So you'll be able to put queries through this platform, and we'll get the most suitable lawyer to give you a call and offer you an insight as to whether or not you think you've got a case. But if you were calling me up about that recovery, well, I'd be saying nail them on it 100%. Right, any more for any more? I'm conscious it's getting towards 3, so it's nearly time to. Can we slip off to the pub now? Or was that still the 19th? I'm not sure, but I'm sure you can go somewhere and have a drink. It looks quite sunny from where I'm sitting, and I know most of you.
Hi, yeah, I
One more question, yeah.
did want
Go for it.
to ask actually.
I'm not sure if we've
Your
lost.
signal might be bad, Nick.
Could be worth typing it out if you can.
I'll message her separately.
Yeah, but we'll wait to answer that question. We want to make sure that all questions are answered. Anyone got anything else? Can be completely random, nothing to do with liability training. Anything that members of council might be able to offer you a bit of an insight on.
Yes, if I could ask a question, please. I basically just wanted to get your opinion.
I think we might have lost you. Not sure.
I have messaged her separately just in case.
Right, so I wanted to ask your opinion on liability case.
Nick, they can't hear you at all properly. You're breaking up terrible.
Maybe, Adam, has anyone got Nick's mobile?
I've got it. Yeah.
Give her a buzz and see.
I've
can speak for her through the.
Yeah.
Through the medium of whatever platform we're on today, Zoom, I think.
Zoom talk.
Yeah. But whilst Adam's making that call, anyone got anything that either Tom or Darren might be able to help you with, particularly tricky?
I think my Zoom is playing out by camera. I don't know if you can hear me.
Not at the moment, but I think Adam's going to call you, Nick. It's going to be the best question ever, I'm sure.
I had a quick one, if I can jump in.
Go for it.
Here, Nick. It's quite interesting to hear when you talk about fundamental dishonesty that I've kind of always pictured it as examples of they were on there. So Matt gives an example of someone's on their way to the concert, and then they're on the phone call to their solicitors saying, "Yeah, I'm bedbound, I can't do anything," and you go, "Well, that you're actually on the way to a concert." So it's things like that rather than actual nuts and bolts of the circumstances. So it's really where do you draw the line of? So we see lots of circumstances where someone can be just mistaken. You roll back in traffic, no you didn't, you hit me in the rear kind of thing, or who encroached into whose lane, and so you can forgive things like that. So to give a quick example, my policyholder is waiting at a side road to pull out, wheels are fully turned to the right, looks to the left. It's a notorious junction where the person comes to the left, cuts the corner, and then takes off her front corner. She's behind the giveaway lines. He says, "Oh no, I was stationary, you just pulled out into me." A chap across the road who actually is working in a garage has to bring his trolley jack out to move our policyholder's car because the wheel's been wrenched. So it was on full lock, and he says it's clear to him, he didn't see the accident, it's clear to him this is where the accident took place. It wasn't pulled out, and she wasn't shoved back behind the line. So I see that as the guy that's coming from the left and turning into the side road has just clearly made that up. He wasn't mistaken in any way. He's just made up that that's what's happened. So where do we stand with, other than saying your client's wrong, our client's right? This is what the chap at the garage has confirmed. You have clearly just lied. You're not mistaken. Where do we draw the line with apart from just using it as a negotiation tool and a lower offer, can we just say no offers? You have just completely made this up. Where do we stand with that?
So, well, my view, it all depends on the factual matrix. So it depends on, going back, first of all, go to RTAs generally. I think Hetty said a point that, and I agree with that credibility can run from a road traffic accident through to injury. Fundamental dishonesty does definitely apply more in terms of personal injury cases than anything else. It'd be unusual to plead it just in an RTA itself. But however, the court always has a duty to see whether somebody's lying, irrespective. Okay, so normal the case will be version A is accepted, version B is rejected, and it's just the fact that version A has got it right, version B has misrecollected how the factual matrix leading to the accident has occurred. Over time, they've convinced themselves of something. However, if the court comes to the view that one version of events is, using your words, just made up, then they can find, the court has a duty at that point to say, you lied and you're in contempt of court. So as far as you're concerned, you wouldn't go off and plead FD on that. What you'd be saying is, this is our version of events. We can't accept your version because of these reasons. And we have some concerns about the veracity of your version for these reasons. And then you let it play out in court, and then you would raise it with the court, or the court will make that finding. I'm not sure if that totally answers your question, but maybe that helps.
Yeah, I think so. It's really, I don't know if it's just a bugbear of mine where you look at this and you think this person's just lied. They're not mistaken. They've just openly lied, just the same as they might lie to a medical expert. But I've kind of not seen it with the same, as holding the same weight of lying. If that makes sense.
With RTAs, I think the court does take the view that it's more likely than not people are mistaken in their recollection as opposed to them lying. But I have seen cases absolutely where the court is saying, this is not possible on this evidence, you are patently lying, or more actually, where they've invented an independent witness that's happened to be standing at the bus stop, and when you see the photographic evidence, there was nobody at the bus stop. It was just a lie. So it does very much depend on the factual matrix. You can't rule out dishonesty in that context, but I agree with you, the courts are more reluctant to find it than they are in an injury case where you're saying quite clearly they couldn't possibly have been injured because of the force of the accident or the factual matrix thereafter and so forth.
Not wishing to sort of put you on the spot, but just kind of sort of intrigued really. I had a case recently that created a bit of debate in the office on which course of action was the best. But a very brief summary is, it was quite an old claim where the claimant was a personal trainer and a weightlifting coach. And she had different injuries from her CNF and GP report to that were then later presented in an orthopedic report, where she'd added in vertigo and tinnitus. But we had quite a lot of good social media evidence on her, where she'd been doing charity skydives, flipping tractor tires, doing CrossFit. You know, sorry, I'm not a gym person. So we had lots of evidence on her that suggested she was nowhere near as injured as she was making out to the expert. We even challenged this in a letter to the solicitors, who came back to us and said, no, we've spoken to the claimant, and she's confirmed that actually, coincidentally, there is another person in the same city with exactly the same name that does the same occupation as she does. But those bits of information you found are not our client. But just to be safe, send us a picture. So we sent them a couple of pictures, but an hour later, they rang back and said, can we have an off the record chat, please? And basically, long story short, it turns out it was their client. She'd lied to them about a variety of different things, including trying to get out of that as well. We already had an offer on the table, quite a lowish offer compared, because we accepted that the majority of the injuries were genuine. And that the claimant itself could have probably got quite expensive. And we had quite a low offer on the table. Would you have at that point maybe withdrawn offers and just gone straight for fundamental, or would you have been happy that actually there's still a risk and, you know, a low settlement is still a good deal?
personally, I guess it would depend on your insurance client. And of course, as counsel, we don't get to deal with that. If the insurance client is, look, all we want is to get out of this commercially as low as we can, we don't care about the principal, then you would leave the offer there and try and walk away and go back to your client and say, look how well we've done. However, if it's a case that no, it's the principal that's more important here, if they're lying, then we're going for this and we're going to take it to trial. At that view, I withdraw the offer completely.
Do you think, you know, at trial, it would have been strong enough potentially for a fundamental argument, given that there was quite a bit of sort of discrepancy in what she was saying?
Absolutely. I mean, she's lied. I mean, she's saying that she can't do all these kind of things, and then you've got photographic evidence of her doing, I think, did you say skydiving, heavy lifting, all the things you shouldn't be able to do with the kind of injury I presume that she alleged she had. It seems to me, on any view, 9 out of 10 judges are going to take a really dim view of that kind of evidence. And as she's already lied to her solicitors, I mean, chances are, I presume they probably would have come off record at some point, and she'd been doing this herself, so she'd have been in some real difficulty, I would have thought. So depending on the client's view, but all things being equal, I would have withdrawn the offer and proceed. Yeah.
Okay.
I agree, and worth me adding, I ran basically that case last year. We had a big guy claimed to have suffered a whiplash in a relatively minor RTA. He's a personal trainer. He had an Instagram page, you know, advertising his services. It had video after video of him working out at the gym. He was put under pressure with FD all the way up to trial, but said he was running it. His answer under cross-examination at trial was effectively, well, I was still using the gym, but I wasn't able to do the things I used to do. You know, normally I lift huge weights. Now I was just lifting minor weights, but the judge wasn't having it. And the judge found him to be dishonest. There were 2 defendants in the case. He had to pay the costs for both. So he went down for 30 grand in costs for a relatively modest whiplash claim. So that sort of social media evidence can be very, very powerful. Yeah.
I actually had a case as well. We had a guy once who was claiming all sorts of things. He basically can't lift anything. And we had we sent somebody out with a video. They climbed into the tree next door, looked over into his garden, and there he is lumping sacks of cement around. Now, we made the mistake of not going back twice. So we only videoed him once. So his excuse was, yes, I had one good day, then I was in bed for 2 weeks. But the judge was having none of it. Now, I accept we made a mistake. We should have gone back a second time. But the judge was absolutely, once you've seen somebody say, I can't do A, B, and C, and then you have evidence showing them doing more than A, B, C, they're in a world of trouble at that point. So for me, you go for FD at that point. Completely.
Yeah, I guess the beauty of social media is they're almost sort of doing surveillance on themselves, aren't they? And then publishing it for everybody to see. So
yeah, who'd be a personal trainer and make a PI claim? It's obviously unsustainable sort of claim to make, but I agree with Tom and Darren. I get that offer off the table, nail them for FD. I deal with a lot of chronic pain cases, and we often get the argument put forward to us when we get decent CCTV, which is, oh, you know, you filmed them on a good day. I think back in the day, it seemed to be a relatively sustainable reply to submissions of FD or back then, you know, call it something different. But I think nowadays, securing a finding of FD is more achievable than it used to be. And I would be taking that off the table, Steve, and saying, you know, we're going to trial or
it's settled. Sorry. So yeah, the outcome is the outcome is we thought it was about a 30 grand claim, and they went away with 5.
So you've done a good job there for Ageas. You've limited. You've got a guaranteed, you know, settlement there, limited your indemnity spend, but I think, I think you're going to see more fraudulent cases because of this OIC. It's a virtually nil costs bearing arena for claimant solicitors, and you're going to see, I think, more widespread fraud in arenas wherein the claims are costs bearing. So definitely something to be lied to. You know, FD is something that, you know, I think it should be probably advanced more frequently if there are, you know, concerns such as that with the claim.
I think as well, commercially, you've settled it, you know, good settlement. You've always got to bear in mind, just because you've got a finding of FD and enforceable cost order, you've still got to get the money, because their insurer is not going to back them anymore, the litigation insurer. So you are pursuing the individual for the money. And if they don't have property, you know, if they're not earning a lot of money, they're not going to have the money to pay your bill back. You're going to spend money on enforcement. So there is, sometimes commercial merit in just saying, okay, let's just get it done and dusted.
Yeah, and I guess that there's still that risk that it could go to trial, and the judge on the day, despite that evidence, doesn't feel as though it is. I suppose it's never guaranteed, is it? I guess
exactly. Well, it's pretty well. I think it's unheard of in court for a claimant just to go, yeah, you got me, I'm right. Yeah. They always have an answer. It may not be a good answer, but they have an answer, and of course there's a chance a judge will accept it. So of course there's always risk at trial.
Yeah, I think litigation risk you can never rule out, and judges are strange things, but on that factual matrix, I think you probably 9 out of 10 judges would find in your favour.
Yeah. My luck would mean that I would find that one, though. That's the thing. I'd find the 1 out of 10, guaranteed.
One benign judge, yeah.
And look, we can always, almost within, I think it takes us less than 12 hours to perform quite wide-ranging asset checks on these claimants. So, Tom's point is a crucial one, because, why would you go after a man or woman of straw? There's no point. So yeah, absolutely. We definitely would suggest pushing for those quotes to be disapplied in any situation where FD is found, and get your money back for you. Because why should you pay the costs of defending an entirely unmeritorious claim? It's not fair on Ageas, it's not fair on the policyholders, and even more broadly, it's not fair on the public, because it increases the premiums associated with insurance.
I spoke to Nikki, so I have her questions, if we want to go through them. The first one she had, mainly obviously to Tom and Darren, is going to be, she's got a case at the moment where our insured is turning right into a side road. There's a motorcyclist behind her that's overtaking, and lo and behold, they've had a collision. Question comes, obviously, we know there are multitudes of case law that says those cases always or predominantly settle on a split liability basis. Her question is that, in your opinion, is that always the case, and is that where we should always be opening our pitches, or is it a case of, should we be denying these cases depending on what's outstanding, and what would, if you think we've got a case where we could succeed on a full denial, what would be the situation where you think we would be wholly successful on that case?
Well, in terms of the risk of split liability or some form of split, you'd say it's pretty high on that factual matrix, because of course, first of all, for the motorcycle, he's overtaking near a junction. So that's the first breach of the highway code. Secondly, the driver has got to be safe and sure that they're able to turn right before they do, i.e. check your mirrors. Now, there are blind spots that we have to remember. So the one scenario in which I could foresee immediately that the driver may not be culpable at all would be if at the time when she made the turn, having checked the mirrors, she couldn't see the bike, it was in a blind spot, therefore she thought it was safe to proceed. Can't do much more. Maybe you could have looked over the shoulder as well, but generally driving people check rear view, side mirror, they don't really look over the shoulder anymore. But generally on a case like that, I think the fault be somewhere between both of them, and certainly the motorcyclist in overtaking near a junction.
That's fine. It's a very key habit for us, obviously in those split ones. Oh, Nick's messaged me saying she can hear, but she said the bike was behind a lorry at the time, so she couldn't see him when she made the turn.
Well, that changes everything, because if you check the mirrors and there's a responsibility to do so, and there's a huge obstruction behind her, at that point she's got to, I think she's entitled to say, well, it's safe to turn. If the bike then comes from behind the obstruction, overtaking at the junction, well, I think the bike may be completely culpable in that situation. It all depends on the factual matrix.
I was going to say, would we have to evidence that there was a lorry behind, or would I take it was just come down on the day of what our insured statement specifies, that there was a lorry there, whether we can prove or disprove that?
I mean, if you've got independent evidence from the lorry driver to say I was right behind as well, great. But or photographic evidence taken at the time while all the traffic's in situ and you can see the huge lorry. But at the end of the day, you don't have to have corroboration. What you have is your client saying, this is the factual matrix. And then if he turns around and says, no, there's no lorry, I was there, you've just turned straight into me, well, then it's a matter for impression of the evidence of the witnesses at court, and the judge will make that decision. But if you got corroboration, great. Otherwise, it'll just come into the witness statement.
I think something that just immediately jumps out to me is if you're saying there was a lorry behind me as the driver that was obscuring my view, presumably the bike must at some point have pulled around the lorry as well. And so it should have been there to see next to the lorry for a second or two as well. So I don't know that that would necessarily help you, but it really does turn on the specifics of the case, I'd have thought.
Okay, taking that point, but then it would depend on the speed of the motorbike as well. So if
Yeah,
the bike has approached at speed, come from behind an obstruction and is there, then what more can the driver do? If the driver's looked, I don't think the duty is high to say, well, if you've got an obstruction behind you, you've got to foresee that possibly a motorbike is going to pull around an obstruction at a junction and overtake. For me, at that point, the motorcyclist would be probably culpable. But I take Tom's point. It all depends on the factual matrix.
Cool. Thank you. And her second question, more of a hypothetical than anything else, with the LIP obviously go live date and the presumption, maybe correctly or incorrectly, that, you know, when liability is denied, these cases are going to take some considerable time, obviously, to go to a small claims hearing, potentially, you know, months and months down the line. Do you see these cases, you know, drying up? Do you see solicitors just sitting on these cases with no funds, obviously, forthcoming for them, and proceeding with these cases? Or do you think by making what could potentially be punt for liability cases where we've got a reasonable opportunity of succeeding on a full denial, but we know deep down probably there's going to be some form of split? Or do we open with a denial on the proviso that maybe they will, you know, lose interest and due to the time and elapsing and things like that? Or whether it's a case of we should be accepting these in with a proportion because of the cost implications on there. You know, if we accept it in, the claims are relatively small value and we know there's no cost associated with them, whether if it goes to obviously a hearing, then we'll have, you know, barristers' costs and all that sort of stuff on these cases.
I think Tom knows a lot more about the portals than I do, so I'll helpfully bow out at this point.
I mean, it's all speculative at the moment. I think my feeling at this point is you've just got to treat them the same as you would any other claim. I wouldn't count on litigants in person just getting bored or not seeing it through, because, you know, I suspect a lot of them who've taken the trouble to read the 65 pages of guidance and fill out the forms are probably invested enough that they will run with it. So I think you do have to just treat it as you would any other claim. As you said, the main difference is the commercial merit in defending it, because if you're only looking at a, you know, 500 quid payout, whatever it is on the tariff, you're probably going to spend that on, you know, trial and counsel's fees anyway in due course. You're not going to recover your costs at trial because of quocs unless there's FD in it. So I suspect commercially there may well be some merit in just getting rid of them. But obviously if you think you've got an absolute winner on liability, then go for it. But I think that's the most I can say about it really at this stage. James, I don't know if you've got any differences.
Yeah, it's a really good question from Nick. I think that was from also. My sense is that you are probably going to have far more liability disputes going to trial in the OIC than in any other arena, because of what Nick has recognised in the course of our email and what Tom said, is that the cost consequences associated with that liability trial, because obviously we've got to have the liability trial, then the quantum trial, they're negligible so far as you're concerned, really. I would be saying, look, if you've got a relatively strong case, deny, get your evidence, gather all of the contemporaneous documents and material that we've discussed during the course of this exchange, get it served, get it disclosed, and go to trial on lots of them. One of the caveats I might offer, though, is the sort of scenario where, in the background, you fear as though, whilst on the face of it, it's a claim submitted by the OIC for a relatively straightforward soft tissue injury, maybe a bit of non-tariff chucked in there as well. There is this slight risk that in some cases, the claimant in the background, their condition will develop and deteriorate. It might turn into a sort of pain case. You can't nip it in the bud as easily as before because you're going to a trial on liability first. Then you're almost going all the way back to the beginning, and then you're having the trial on quantum. So whilst yes, on the face of it, the cost consequences associated with running it are negligible, there is also maybe the points to be had in the back of your mind. Is this a hopeless liability case? And if so, are we looking at a claimant here that potentially has a few of the kind of amber or red flags associated with their PI claim, which we think could actually spiral? So if we think yes to that, say for example, I don't know, it's a classic potential chronic pain one, loads of psych wrapped up, pre-existing conditions, etc., 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 and you think, you know what, this could just deteriorate, and I could end up looking at a claim that actually gets plugged from the portal and turned into a multi-track pain case. We might then want to say, yeah, on the face of it, not going to cost us anything for this liability dispute, but are we going to create a bit of beast as a result of that? You know, that's quite a narrow example I'm offering up there, but it's just really to sort of have that kind of wider degree of mindfulness when you're making a liability decision, thinking about what is the claim that we're being asked to meet and what is potentially the claim that we're being asked to meet. But on the face of it, you know, if you're not concerned, you don't have any sort of concerns like that, then if you had a relatively good liability case, you know, it's not going to cost you that much to run it, to be honest with you. You could end up avoiding, you know, a £9,990 case at the most on the Ageas book. So yeah, aligned with what Tom says, but also sort of maybe look at it even more broadly than that. Tricky. I mean, what we will do is certainly we're watching it very closely. We've got a team that's going to be set up to manage those cases in the litigated stage. And I think probably beginning of next year, once we've seen a few of these cases go through, we'll be in a much better position to offer you some actual reflection. Whereas at the moment, it's a whole bunch of you know, people across the insurance industry in all various different roles, kind of predicting what they think might happen. But I think one of the things I'm not surprised about is the low level of litigants in person. I think, roughly speaking with various different insurance companies, seems to be about 10% only with regards to litigants in person, which isn't surprising on account of what Tom said, the length of the guide of 65 pages. I mean, it's just remarkable that they ever sent that out. It's, you know, it's going to put off so many people.
Yeah, well, I think it's a similar situation for us. I think a vast majority of our cases are represented. Yeah. We've had some direct people, which is, you know, I think, a surprise to some of us. But yeah, I think just given the rough maths of what I've looked at previously, I think we're around 15% representing themselves, and the rest of them are represented by a firm of solicitors.
Admiral or Carpenters, I guess.
Admiral Carpenters. Slater and Gordon at the moment are, funnily enough, absent from everything, which is alarm belling a little bit.
I think your Carpenter's always going to be the one, and Admiral Law, I think, to be the two main players. That seems to be what I'm hearing across the industry. But yeah, I mean, my word, I mean, if it were the other way around and you had sort of 85% litigants in person, it'd just be a nightmare. Those cases are not easy cases. Great. Good questions, Nick. I know you can't see us, but you can hear us. Thanks for those. They were useful ones to cover off. Does anyone else have any questions? David?
Well, I don't have any questions, and it's quite intriguing that, you know, Council's Clerk is contributing to this now, but I don't know if anybody saw the case of Beasley this week, but just going back on one of the comments that was made about the ability of the claimant to pay if they've got FD against them, but it was a elderly chap who, I think he was a lorry driver, got injured and was found fundamentally dishonest because of surveillance, that he'd gone and hired a wheelchair. He and his wife drove up to the medical centre they were going to, got out, the wife carted him into the medical centre and obviously complaining about all manner of injuries, etc. On like 3 separate occasions, and then couldn't do any lifting and was seen on surveillance at the garden centre lifting compost bags. So I think the judge's summing up was, well, he came clean after after it had been disclosed now, but yeah, sorry, you're going to jail for 6 months and £60,000 worth of costs against you. And I think there's consideration being given against about going against for his wife as well, because being complicit to the whole thing. But yeah, like I say, I don't know what his ability to pay is, and the circumstances around that. But I just found it to be an interesting case.
Yeah, but thanks for that, David. It just shows how serious the courts take these instances of dishonesty. It's no longer tolerated as widespread as it used to be. So yeah, another really good illustration. Thanks for that, David. Stepping outside the role of your day-to-day.
I got really nervous there, by the way. I don't normally do that.
Nice one. Well, anyone else for any more? No? It's too nice outside to still be in here. Well look, from my perspective, a massive thanks to all of you from Ageas for attending today, for watching the material, and also to 3PB, to Tom, Hetty, Darren, and also Ed and David for coordinating the piece. It's been really interesting. I've learned a lot personally today. And the last message really to all of you at Ageas, from myself and everyone at HF, is that we're a team in this, and if you guys ever have any questions, points to put by us, feel free to just drop me an email. We'll get in touch with you, because it is really a complete team game to try and win these cases. It's Ageas, it's HF, and it's instructed members of council. When 3PB get involved, so it's really a top to bottom thing, all round, all together. So yeah, that's the message from us. Just get in touch if you ever need us. But otherwise, wishing you all a very, very good weekend.
Yeah, thank you very much.
Thank you.
Thanks a lot. Cheers.
Thank you.
Thank
everyone.
you.
very much.
Thank you all.
Great, guys.
Bye-bye. Thanks all.
Thanks
Bye-bye.
all.
Bye-bye.